So I can begin?
Yes, let's start.
Yes, now we have made this webinar after the conference, which is open also to non-members, in order also to attract them, to make them understand what we are doing. And we will deal mainly with the pros and cons of CISG in under three different aspects. One is the conclusion of contracts. How does it work when you have contradictory general terms and conditions? What applies, what not? How does it work under the CISG? Silvia will deal with this with Riccardo Gaiani. Then I have proposed the team, how can the seller defend against the buyer who invokes defects without needing to discuss the existence of them? So on merely formal aspects, together with Yeshim Atamer, my colleague here. And then seller's defenses to prevent contract avoidance by buyer, because this is another problem. Of course, if you can prevent him to avoid the contract, you are happier. And this is Burkhard Pilz and
Christiana Funtulakis.
Christiana Funtulakis. So the idea is to have these presentations and also to involve people who do not know enough about IDI, show them how nice we are and what a good atmosphere exists in this group of people, which is really very, very important, I think, what we have created, the atmosphere, and hoping also that some of them will join us. And so I think you wanted to add some words?
No, that's fine. I think that it's good maybe to start so that we will have enough time for all the speeches. And then I would just want to say that we will keep the questions for the end. So as you have seen from the program, between 3:30 and 3:45, we will have 50 minutes for all the questions that you can put on the chat. Okay.
So now it's up to you, Silvia.
Thank you very much. Okay, we will start. So yes, sharing the screen. All right. Okay, can you all see the screen, the slides? Yeah?
Yes.
Perfect. Okay. So, okay, first of all, I would like to introduce my co-speaker, Riccardo Gaiani, Commercial Senior Legal Counsel at Valentino Milan. And together we will deal with the topic of the conclusion of contracts through the incorporation of general terms and conditions. I would say, of course, in many cases of distribution contracts or franchising contracts, this issue is not relevant because in many cases, of course, the general terms and conditions of sale are attached to the contract, to the framework contract. But there are also situations where, of course, this happens. So the conclusion of contract through emails, exchange of emails, and so. For example, when, I don't know, a brand is selling to multi-brand retailers or other situations. So I would like to ask Riccardo, what are those situations in the case of Valentino? Riccardo.
Hi, Silvia. Hi, everyone, and thank you for inviting me at this panel. Yes, actually, talking about my experience, of course, we have our retail channel, which is very strong across the world, but we also have our wholesale channel. And so in this channel, we deal with very big clients, but also with smaller clients. Most of the times when we have big clients with personalized boutiques or corners, of course, we execute proper and structured agreements. But it can happen that when we have smaller and multi-brand clients, we manage the orders by sending them our general conditions of sales by emails. Sometimes they come to our showroom in Milan, and we provide them with the paper copy of the general terms and conditions, and they sign them here. But sometimes, since they are from all over the world, they connect remotely, and then we send the general terms and conditions to them by email. In this process, the client places an order, then we send by email the general condition of terms, and then we send back an order confirmation. So this is generally what we do with our wholesale channel.
Perfect. And what is your experience with the application of the general terms and conditions in general terms? Then we will go into more details with the hypothetical, but in general terms, what is your experience on that? I mean, as Valentino.
Well, luckily we have not experienced any major problems with clients, because as I was saying, major clients with personalized space has their own proper agreements, and together with the general conditions of terms of sales, we try to secure our business by requesting smaller clients and multi-retailers with particular conditions. For example, they need to provide bank guarantees or cash deposits before we ship the products. But of course, we need to be very careful in these conditions, because also if you have a cash deposit or a bank guarantee, that maybe they place big orders which are not totally covered by this cash deposit or bank guarantee, and then general condition of sales needs to be applied.
Sure. Yes, that's really good. So even if you don't have this type of litigations or this type of problems, we will deal here now with a hypothetical. So assuming that there is a problematic situation that we should assess and evaluate. Would you like to describe this hypothetical, Riccardo, please?
Yes. Together with Silvia, we have tried to think about the case that could be as much as possible close to what happens in real business every day. So here we have a US client, so a client based in the United States, who is purchasing an order to the brand, a brand which is based in Italy, by email. So a client who is not coming to the showroom. And in addition to the main commercial terms, the order refers to the buyer general terms and conditions, which are attached to their email when they send us their order. In the buyer's general terms and conditions, we find the application of Californian law and the exclusive jurisdiction of the Los Angeles courts. So in this particular case, the brands receive the order and then send back to the US buyer an order confirmation by email. When sending the order confirmation, the brand includes reference to its general condition of sales, and the specific points of these general conditions of terms of sale is that they provide for the application of the Italian law with the exclusion of the CISG, and also they provide for the exclusive jurisdictions of the Court of Milan in Italy. After this initial exchange, the brand sends the order confirmation. Then there are no further exchanges with the buyer, so between the parties, and then the buyer proceeds with the first partial payments of the goods in compliance with, of course, the order confirmation. At this point, as it usually happens in business relationship, the brands deliver the products to the buyer. In the order, they indicated the free carrier Incoterm, and the play of the brand. So the delivery is made according to the general condition of sales that the buyer has accepted by accepting the delivery. At this point, something happens in the case that we are talking about here. The delivery is made in delay by the brand, and a few months later, what happens? It happens that the buyer claims in first instance that they have suffered damages from the late delivery. As a second point, they refuses to pay the remaining part of the price of the goods. And as a third point, they threatens to bring an action against the brand before LA courts according to their general condition of sales. So at this point, we have figured out that the brands call his legal consultant, Silvia, and to try to understand what could happen in this situation where we have different general terms and conditions and this chain of events which can result in a doubtful application of the first or the second general terms and conditions.
Perfect. Thank you very much. So yes, now you come to me and what can I say? First of all, I think it's necessary as a first step to make an evaluation concerning the conclusion of the contract. So trying to understand how the contract was concluded and therefore what rules, what provisions will apply to this contract. So since Italy and USA are part of the CISG, the evaluation, in my view, the evaluation concerning the conclusion of the contract and the valid incorporation of the general terms and conditions shall be made based on the applicable articles of the CISG. In fact, even if one of the terms and conditions, particularly the brand's terms and conditions, provide for the exclusion of the CISG, even in that case, we should ascertain whether this exclusion is valid or not. And so I think that I would regard to all these issues based on the CISG. First of all, regarding the conclusion of the contract, there is a general principle in the case law which applies the CISG, according to which when there are exchanges of general terms and conditions, there is the general terms must be made available to the other parties. So we have seen that here both parties made clearly available the text of their general conditions to the other party, because each of them not only referred to the general conditions in the order and in the confirmation order confirmation, but also they attached the text of the general conditions to the email. So I would say that both general conditions have been validly incorporated. So here we pass to the issue of the battle of the forms, because we have the two general conditions and we must see which one prevails. In my opinion, I would follow the principle of the last shot rule, which is I think the most commonly principle applied by case law, and also really consistent with, in my opinion, of course, with the rules of the provisions of the convention. So we can see the US purchase order as an offer, and then the brand's order confirmation, which of course includes provisions totally different and from those included in the offer, must be regarded as a counter offer. And then the brand's counter offer has been accepted by the buyer with his payment. So there is an acceptance with this first payment. So as a conclusion, the conditions provided in the brand's order confirmation, including the general terms and conditions, shall apply, but the brand's general conditions, however, have not been accepted in writing because, okay. Of course, this can be criticized because others could think that another principle, for example, the knockout rule should apply instead of the last shot rule, but this is my interpretation, my view in this regard. But
at this point, Silvia,
yeah.
if I can please add, of course, the brand's main concern is how to avoid going to the US in front of the court. So do you think we can avoid going to the US having a jurisdiction clause?
Yeah. So you're right, because I'm perfectly aware that your first concern is that you have the buyer who is threatening to start a claim against you before the LA courts, and this is really, I'm sure, and I know that it's really not what you want. So let's immediately deal with this issue, which is very important. So it is true that the brand's general conditions include a jurisdiction clause in favor of the courts of Milan. However, as we have seen, such clause has been accepted by the US buyer through a conduct indicating assent, so the payment, but not in writing. We cannot consider this as an acceptance in writing. So if we refer to Italian rules, particularly Article 4 of Italian Law 218, 1995, which are the rules which apply to when parties are of countries outside the EU instead of the EU regulation. This provision, this rule requires the written form approbationem. So it is really doubtful that this requirement can be considered fulfilled in this case. Even if we think of a written receipt of the payment, this could be a proof of the payment, but certainly, in my view, not an acceptance of the general condition and particularly of the jurisdiction clause. So I would conclude that, unfortunately for the brand, the courts of Milan do not have jurisdictions based on this clause. However, looking at there are further evaluations that can be made in this respect, particularly referring to the place of delivery. In fact, Article 3.2 of the same law, 218 of 1995, refers to alternative jurisdictions criteria and refers to those criteria provided by the Brussels Convention of 1968. We all know that this convention has been replaced in the European Union by several regulations. The one applicable now is the 1215. So Italian case law during the years accepted that this reference to the Brussels Convention must to be considered as made now to the regulation 1215. So by applying Article 7.1b first indent of this regulation, and referring, of course, to the circumstances of this specific case, if the goods were delivered in Italy and had to be delivered in Italy according and in conformity with the contract of sale, the courts of Milan may have also jurisdiction over the case.
Yeah, in fact, in our case, the products were actually delivered in Italy, free carrier at the seller's warehouse, according to the brand's general terms and conditions. Correct.
Good. So these circumstances, in my opinion, gives the chance to the brand to anticipate maybe. So one possible strategy based on this situation could be for the brand to anticipate a possible action taken by the buyer in the United States, anticipating suing first the US buyer in Italy, maybe claiming payment with, since it has to pay still a part of the price. And so anticipating with an action, a proceeding in Italy. In this case, even if the buyer would go before the courts and start, in any case, even notwithstanding that, a proceeding before the LA courts, and even assuming that the LA courts will give a decision, will end up with a decision against the brand, the buyer, the US buyer, will have problems in recognizing and enforcing such decision in Italy, following this interpretation, and if, of course, the brand will start first the proceeding in Italy. But these are, of course, details. We can go then, which solves the problem, of course, that you were concerned about, clearly, of the jurisdiction. Then, of course, we have to deal with the law applicable to the dispute. So which rules, which provisions, which rules will apply? Because we have seen that the brand's general conditions provide for the application of Italian law with the exclusion of the application of the CISG. So, therefore, we must refer to the Italian Civil Code instead of the CISG. We could also make an exercise and check whether by applying the Italian rules of the Civil Code instead of the CISG also to the conclusion of the contract, we would come to the same conclusions. And the answer is yes. So Italian law has similar principles similar to the CISG Convention of the offer, counter-offer. So we could come by applying these rules to the same conclusion, so that the contract has been concluded based, incorporating the terms of the order confirmation of the brand, including the general terms and conditions of the brand. And this acceptance of these rules, of these provisions by the buyer have not been made in writing. So it's a conclusion, but the acceptance is not in writing. We must then consider that article under Italian law, particularly in the Italian Civil Code, we have this article 1341, second paragraph, which provides for a specific formal requirement for the effectiveness of the general terms and conditions in B2B transactions. Particularly, in addition to the acceptance of the general terms and conditions, it is required that certain provisions, particularly so the unfair clause, they are called clausole vessatorie in Italian, they must be accepted specifically. So what is in practice we do is that we have a first signature of the general conditions and then reference to specific provisions of the general conditions which are referring to these unfair clauses, accepted with a double signature. Of course, in this case that we have seen, we didn't have this double signature, so no. There was just an acceptance, but not in writing. So, in principle, this provision, this rule, will not apply, does not apply to jurisdiction clauses, but this is irrelevant here because we have seen that in this case the jurisdiction clause was not applicable. Also, this rule is not does not apply in principle to the clauses providing for a delivery, the delivery clauses regarding the place of delivery. in principle. Then, of course, we must evaluate with reference to the specific text of the clause. But in principle, the clause that we have used for the purpose of jurisdiction does not require a double signature, so is valid and is effective. However, this article 1341.2 applies to clauses limiting the seller's liability. So, for instance, the one regarding delays in delivery that are relevant in this case. So, these aspects should be carefully considered by the brands in the defense, in the merit, of course, of the proceeding, because if there were possible limitation of liability clauses provided in the general conditions, these clauses would not apply since we do not have this double signature acceptance of these rules. While I must say, if the CISG had not been excluded, as it was here the case, possible clauses limiting the brand's liability for delays in delivery, provided that excluding the case of fraud or gross negligence, would be applicable, because unlike the Italian, this provision provided by Italian Civil Code, the CISG Convention has a principle of freedom of form in its Article 11, which prevails over this specific requirement. So that would be our conclusion of this case, just to make an example. And yes, good luck for that.
Thank you, Silvia.
Good. Thank you very much.
Thank you for the exercise.
Okay, very good. So, okay, so now we will go to the other speakers and okay. No, sorry. I need to share the screen before. Okay. No. Can you all see? Okay, good. So I will pass the floor to my father and Yassim Atamer for the next presentation.
Yeshim, how do I call you?
You call me Yeshim. Yes, that was absolutely
Yeshim.
correct. Yes.
Wonderful. So actually, there was a bit of misunderstanding in the title, because my idea of the title was how can the seller defend against buyer invoking defects without needing to discuss the existence of the non-conformity. While here we have formal defenses of the seller. So my idea was a bit wider than but actually we will in any case
Discuss the same.
on the formal. No, it's not exactly the same thing, because there are situations where it is not a purely formal defense to say, for example, that, I don't know, it's not formal, but actually it does not regard really the substance of the matter. So, but this will be dealt with by the following group, following speakers from Toulakis and Peets. And so we will concentrate on this.
Shall we maybe change the slides? I think somebody should be. Yes, that was the introduction. Probably. No?
Yes, so this is the idea, the formal defenses. My idea was, when we deal with seller strategy in response to buyer's claim to avoid the contract, we should not forget seller's defenses that do not regarding specific defects, but more generally the quality of the alleged breach in cases where it lacks the requirements for being considered as fundamental, in particular with reference to defects of minor importance or defects that can be easily remedied, because in this case, you do not enter into the details of the problem of the real actual defects of which you are speaking. Any case, we keep it in mind, but we go on here. Yes, the formal defenses. This is very important. Why is it very important? Because one of the difficult problems we have to face is a difficult discussion about what is the defect. Is it your fault? Is it my fault? And so if you can avoid all this, you avoid a lot of problems, and you can say very simply, sorry, we don't discuss these matters because we have this one of these formal defenses. And these formal defenses regard mainly the timely examination of the goods. If the goods have not been examined within a sufficiently timely approach, the notification of the non-conformity, you must have told in time to the seller that there is a non-conformity, that you think that there is a non-conformity. And what is also very, very important, the specification of the defect invoked. You must say what is, you can't say simply, it's bad. My clients say that the goods are not nice, are not, they don't like them, but that's not the reason. So let us go to the first. The first examination duty. So in Article 38 CISG, it is said the buyer must examine the goods or cause them to be examined within the shortest period as is practicable in the circumstances. This, of course, difficult to, it may be a problem. What is that short period? And here, of course, case law is very, very important because it gives us an idea about the enormous differences that may exist from case to case according to the circumstances. Do you want to go on a piece here? I don't know. Shall I?
No, we had said that I'm starting with 39. You are going through 38.
So I go on here. Okay. So here we have a case as an inspection period of 2 weeks is sufficient and appropriate for non-perishable goods that do not fluctuate greatly. Also, immediate examination with regard to the quantity is expected. Okay, then time frame. Spot checks of the delivered ham could have been done within a time limit of not more than 3 days. Of course, because ham, so you see here we have only 3 days, which are right. And here the buyer should not have postponed the inspection of the ties, because here you have problems of conformity that you can detect immediately when you receive them, and so you should do that. And so we have also this period of time of not even 4 months did not constitute a reasonable period. So we have this case law which helps us to understand what is the right term, and so which can guide us if we have a case. Then examination, you must make a good examination, not just the goods on top. This is interesting. A unique hand screen printer. This case is interesting because it regards a print by Andy Warhol, framed and kept behind acrylic glass, sold to a company, and the company purchased it for purely decorative purposes, not being a trader of artwork. So it would have differed if it were a company that has to resell it and that must make checks that were not necessary here. The buyer gave notice of the non-conformity 14 days after discovery, but 20 months after delivery. But not being an art merchant, he was not required to make a comprehensive examination. So the court held that had the buyer purchased the artwork in pursuit of regular business, arguably would have been required to make a comprehensive examination, removal of the frame. In fact, the buyer purchased the artwork purely for decorative purposes, namely to display it, and so he was not obliged to make this type of examination, and you cannot contest him that he should have done it in time. So we go over to you.
So, okay, thank you very much. Now, thank you also for this very kind invitation. It's a pleasure to be here, and I see we have 123 participants, which is really very good to know, and I hope there are at least some questions. Now, maybe to rephrase again what was already said, the problem or the chance, depending on which side you are, is that if you are not examining and due to not examining on time, you do not notify on lose as a buyer all your rights. And that's exactly why for a seller, it is really a good feature to know about all these examination and notification duties so that you can, as Fabio put it correctly, that you can just say you did not notify on time. As you see, Article 39(1) tells us the buyer loses the right to rely on a lack of conformity of the goods. That means you lose all your rights. You cannot avoid the contract. You cannot ask for damages. You cannot ask for repair or replacement. You cannot ask for reduction of the price. All of the remedies are lost. That means the notification duty is only applied if goods are delivered. So whenever goods are not delivered at all, obviously it's not going to be here the same. We are speaking of the non-conformity of the goods. So that means for all you of those who know about the CISG, it's about Article 35 cases. That means the goods are not conforming to the contract or the convention. But we should also keep in mind that the goods might also have a problem regarding IP rights of third parties or third-party other rights, at REM rights, for example, according to 40 and 41, there too you have a notification obligation. So that means in every type of non-conformity, the CISG says the buyer has to notify on time. Now, as Fabio put it, we have two different provisions. 38, which tells us you have a duty to examine on time in a period with an as short a period as is practicable. So very much depending on the case, very much depending on the type of the goods, and also the circumstances. And then you have 39, which says you must give notice to the seller, specifying the nature of the lack of conformity within a reasonable time. So again, a time period. But normally the courts are going to address these two issues, 38 and 39, obviously together, because at the end of the day, you could use, for example, a bit longer period for the goods, but be very fast in notifying. So altogether, the time frame has to be fitting. If that is okay, then you have not lost your rights. So that means we must look into 38 and then again 39. How fast do you have to let seller know of the non-conformity of the goods? This type of notification duty we have all around the world, one must say. That means especially in B2B contract, it is very normal because businesses on both sides, seller as well as buyer, must be fast. If you are in a sales chain reselling the goods, you have to immediately examine and then make your notification. But one shouldn't forget that we have also non-conformities which you find out about after examination. So that means an examination doesn't show exactly the non-conformity. With machines, for example, but please, I'm going to tell you if I want the slides to be switched. So can we go back again to Article 39? Okay, thank you.
Here?
No, 39. The article is for me exactly fine. But please go back again. I will say, yeah, thank you. What I was trying to explain was that in principle, you have two types of non-conformities. Those which you find about after an examination, that means 38, and those you cannot find out even if you have examined the goods. So that means you call them hidden defects, for example, in many jurisdictions. For both cases, we have a notification obligation. So if you found out after an examination, you must notify. If you find out later at one point about this non-conformity, you again have to notify. Now, how fast do you have to notify? In a reasonable time. So again, here we see a difference to many other jurisdictions, which mostly say immediately, very fast indeed. Whereas the CISG says a reasonable time. That means it doesn't say a fixed time period, like as far as I understand in Italian law, like for example, 8 days. We have this type of period in some jurisdictions. The CISG is much more open here, and it depends according to the type of goods you have. So that means fast perishing goods. We had an example explained by Fabio. You have to notify also very fast, whereas on the other side, according to the type of the goods, you might have even have a longer period. Let's now have a look at the jurisdiction. Can we, yeah, notification duty. So you see here different cases from France, Netherlands, and the USA. For all those maybe not that much acquainted with the CISG, I have referred always to the CISG online case number. So if you just have a look, search in Google CISG online, you will find a website. On this website, there are at least all reported cases on the CISG available, mostly with a translation, at least with an explanation what this is exactly about. So that means if you enter there the case number, which is 5865, for example, you will see immediately the case and all its details. That's the international, let's say, reference code to CISG case law. Now, in the first case, we see it's an ironing machine. The defects were found about by the buyer, the next buyer. That means one seller buying and then reselling. And the buyer said, with the ironing machine, there is a problem. Informed immediately his seller, there was no problem. But the seller himself then passed on this information to the producer of the goods 4 months after discovery. So definitely too late. Absolutely no possible claim here of the CISG buyer. We go down, as you see, notification more than 10 weeks after receiving the computer tablets, again, too late. That means you have to have a look into at least a sample of computer tablets. We had also the discussion above. That means at least the representative amount of sample you have to run through, check through, and see if they are working or not. If not, you have to notify 10 weeks after receiving the computer. So as you see here, the starting point, as I just said, is including 38 and 39. Receiving means the moment where it starts my duty to examine, and then also the obligation to notify. That means altogether 10 weeks, far too long. Notification of defects in tablets 1 month after delivery is too late. So we go even more down. In the United States, we see again here a 1 month period for tablets to have a look, examine them, and then also to notify was found too short. It is good that the CISG has this openness. It is really also open to all the types of the goods, but also, one must say, to the different parties. That means if you have parties which are more acquainted with this type of commercial goods, which all the time are buying and reselling the same goods, there you would also say it is a shorter period because they are used to it. Or if you have a seller, for example, which is always delivering goods which have a minor problem, you would know it. So you are prepared for it, examine exactly, and give a notice much faster. So that means the history between the buyer and the seller is also going to be decisive when defining when exactly you have to notify. Next slide, please. Regarding the time frame again, we see a Ferrari car. So that means here it wasn't sales of an antique car, one car, but still a B2B subject to the CISG. Delay of more than 3 weeks from delivery does not comply with Article 39. So I want to again underline the same. You see delivery. That means 3 weeks is not enough, is too long for examining. After delivery, first you examine, and then you have to notify. So that means don't think that these two time periods are really separate time periods. It's mostly all together. So after delivery, immediate examination, immediate notification also. The period for the notice of non-conformity of the goods under Article 39 starts as soon as the period for examination has elapsed, and amounts normally to 1 week. So that means in Austria, we see here a 1 week period for the notification. Should therefore reach the seller within 2 weeks from the delivery of the goods. So that means examination plus notification, 2 weeks time. It's not that long. So again, if we compare with national laws, which mostly also have this openness when they are following the CISG. For example, Sweden is an example where we have this influence of the CISG, whereas some countries where we have really stricter, shorter periods, but the CISG is also not really that open, that lenient to the buyer, because it is the interpretation at the end of the day which counts. Next, please.
Can I go on this?
Yes. Thank you. Now, what exactly do you have to report then afterwards? That means in 39, you have to specify something. You cannot just say, at the beginning, Fabio said it also, you cannot just say the goods are problematic. That means, again, the idea in B2B, business to business sales contract, why do we have this notification obligation? Because we are mostly in a string sale. That means in this chain, we want to be fast. I must immediately notify you so you can again notify your producer or seller. So that means here, with this notification, I also should know what exactly the problem is. That means you have to go into details. Where do you find this again? 39 tells us you must specify the nature of the lack of conformity. So that means, again, we see that courts are strict. The mere sending of a quality report on the goods sold to the seller does not usually indicate a sufficient will to complain. So that means you have even done more. You send a quality report, which probably says the goods are not that of that quality which we were contracting for, not usually indicating a sufficient will to complain. A mere statement that the goods cause problems or present defects does not enable the seller to determine its conduct regarding the alleged lack of conformity and is therefore not sufficiently specified according to 39.1. Why is it also important for the seller to know about the type of non-conformity? Because in the CISG, Article 48 gives the right to the seller to say, buyer, do not avoid the contract. I am going to repair the goods or replace them, give you new goods. Just don't do anything. And I'm going to, if you have a loss, pay damages, but we are keeping this way the contract alive. This is called the right to cure of the seller. So a seller must know what the defect is if he or she really wants to also make use of this right to cure. That's also why the CISG asks the buyer to say what the nature exactly is of the non-conformity. As you see, the CISG is really balancing the interests of the parties perfectly fine, one must say.
Can I add something
Yeah.
regarding the strategy of the seller? It is very important that the seller knows this specification of the CISG, because he must really check when he receives a complaint. He must check whether this complaint is enough detailed to permit him to understand. And what I don't know if this could be part of a strategy. You could also not immediately take a position, and then after, when you take the position, it's too late for the buyer to be more precise. This I don't know, but I think it's a strategy to be considered really. And then the other thing I want to underline, in Germany, there are very, very many cases where really this has been determined for, this has been crucial for not accepting
The rights. Yeah.
the
And
defect. So I think
this is
and I
one.
don't think that the national laws are as precise as the CISG in speaking about this aspect, which I think is one of the most important ones for a seller who wants to protect himself against the buyer who invokes defects without real reason. Sorry.
Absolutely, absolutely. I must say, as a comparative lawyer, I never ever have seen anything like that written in the code before. So that means, I don't know all around the world, obviously, but at least in most of the European Union countries, I could say that this is really something what the CISG drafters thought about and included specifically. And as you say, in Germany, for example, the next case is from Germany, the buyer lost its right to rely on a lack of conformity of the goods flowers. Why so? Because he said, poor appearance. That means that is not enough. I don't know what exactly is the problem with these flowers. It was neither sufficient to give notice of the mere fact of the bad quality, nor to find fault with the poor appearance of the flowers. So that was not enough, and that means the buyer is losing all its rights. Can we go on to the next slide, please? Now, the 39 to 2-year period. That means, again, probably from all our national laws, we know that there is a limitation period regarding every contractual claim. That is for sure between 6 months in sales contract, mostly, to 2 years to 5 years. You have many different limitation periods. The CISG doesn't say anything about a limitation period. That is left always to national law. That is a procedural law issue mostly also. That means this is left to national law. So that means 39 is only defining that under the CISG, a seller is liable for 2 years. So that means, in any event, the buyer loses the right to rely on a lack of conformity of the goods if he does not give the seller notice thereof at the latest within a period of 2 years from the date on which the goods were actually handed over to the buyer. So that means, in principle, we must always assume that under the CISG, there is a 2-year time period where the seller is liable. The relation of this time period to a national limitation period is another discussion. It is a bit problematic if you have shorter limitation periods like 6 months, 1 year, for example, then mostly it is accepted that it is the 2-year period which counts. But in the CISG, 2-year period of liability. However, you can shorten it. So that means in your contract, you can say the liability of the seller is only 1 year. That means the CISG has freedom of contract. Instead of opting out of the CISG, you can always change some of its provisions, including 39.2. You could say, we only are going to be liable for 1 year. You could also do the other way around. As you see now, the last part of the sentence, unless this time limit, the 2-year, is inconsistent with a contractual period of guarantee. So that means you can also prolong it. You can say, I'm giving you a guarantee for 3 years. So that means now 3 years, the seller is going to be liable. From the moment starting of delivery, in 3 years, whatever the buyer finds as non-conforming, we must have a notification in this 3 years. If the 3-year or 2-year, normally CISG, has passed, has elapsed, then no rights anymore. Can we go to the next slide, please? Now, when we look at the case law, you see also this underlined. It is a very recent case from France. The 2-year period is a notification period, not a limitation or preclusion period, exactly correctly stated. The buyer loses the right to invoke a lack of conformity if he does not notify it at the latest 2 years after delivery of the goods. So that means all rights after 2 years are gone. If the contract provides for an effective warranty period of more than 2 years, this is incompatible with the exclusion period of 39.2. That means all case law also reflecting what 39.2 is telling us, that is, with the 2 years, you can play around, shorten them or prolong them. Next slide, please. So regarding your defenses as the seller, there is also one counter defense of the buyer. So that means the buyer can say, seller, you knew. That means you knew or could not have been unaware of the non-conformity. That means as a seller, you say, buyer, you did not notify on time. And the buyer is now giving a response and saying, you did know or could not have been unaware. In most of the civil law jurisdictions, we have also parallel provisions. The seller is not entitled to rely on the provisions of 38 and 39 if the lack of conformity relates to facts of which he knew or could not have been unaware and which he did not disclose to the buyer. It is a bit of a venire contra factum proprium idea. That means if the seller knows about it, why should he then not really give the buyer his rights? Because he knew. That means a late notification doesn't make any difference. Next slide, please. Here, I think the case law is very important because what does it exactly mean that we have really knowledge about it or could not have been unaware? Because positive knowledge, it's hard to prove. So could not have been unaware must be the proof of the buyer. That means one question would be, if the manufacturer is the seller, shall we say every manufacturer knows about the defects of its own goods? Here again from France, manufacturer status of the seller alone, not sufficient to assume knowledge of the seller within the meaning of Article 40. So again, here the court states something which is very important, protective of manufacturer sellers. That means if you are a manufacturer, doesn't mean necessarily that you know about all the defects of your goods. Again, no negligent lack of knowledge is assumed if the seller is aware of a potential lack of conformity, but assumes that this will not occur in the contractually stipulated use. So again, protective of the seller, that means here too, it is not Article 40 which is going to be applied. That means the buyer is losing his rights totally because there wasn't any timely notification. And then the next slide, please. I think this is now our
Can
last
I
slide
add
also.
something here?
Yes, I think we have 1 minute.
1 minute. You can already go to the next slide, but before
Yeah, that's the last one.
conclusions,
Yep.
on this problem of the knowledge of non-conformity, I think that there is much space for lawyers which have a lot of fantasy to invent situations where they can say that the seller must have known or should not have known. I think it is something where you can invent interesting means to support a certain strategy. But let us go to the strategy. I think these are the points, no?
Yep, absolutely.
You agree. Has a non-conformity been notified timely? Is it sufficiently defined and precise? Has the maximum period of 2 years passed? These are the questions, but I think it's very important for the parties and for those who organize their sales network, no, the internal sales responsible, that they know this and that they pay attention to these aspects when they risk to receive complaints from customers. It's very important that they know clearly these principles in order to know what they must ask, what they must check in case of possible dispute, future dispute. So I think this is something that within companies must be very clearly specified to those who deal with the counterparts, to those who deal with the buyers in the company. This is
Absolutely.
only a practical consiglio, practical advice.
Yes. Okay, I think with that we can close also our session.
Good. Thank you very much.
You are welcome.
So we will pass to the next. Okay. Next slides. Okay.
Burkhardt e Lam.
All right. So Professor Christiana Funtoulakis and Burkhard Pilz, please go ahead.
Thank you very much, Silvia. Thank you, Fabio, for this nice invitation. And I'm happy to speak after my dear colleague, Yeşim Atamer, who presented to you the defenses, or actually the means that the seller has to avoid the avoidance of the contract without having to speak about the defects of the goods. And our task now is to show to you what the seller can bring forward when the buyer comes with the objection that the goods are defective and that he would wish to terminate the contract. Next slide, please. Next slide. Yeah, thank you so much. Okay, so the question is governed by Article 49, para 1, letter A of the CISG, speaking about the entitlement of the buyer to avoid the entitlement of the buyer to avoid the contract in case that there have been defective goods. And one has to say that it's rather difficult to get out of the contract if you compare with civil law legislations that are rooted in the Roman law tradition, such as Swiss law, for example, but also French law, even after the revision that took place. I'm not sure about Italian and Spanish law, you will confirm it. But normally you have just a choice between terminating the contract or asking for a reduction of the price. And then the question of damages will come as a subsidiary means, legal means. Under the CISG, actually, you need a fundamental breach of contract, unless, obviously, you have agreed otherwise, because it's always possible to provide in contract clauses that avoidance of the contract is either even more limited to what Article 49 provides for, or that it is even more extended. So yes, if you don't have anything specific in your contract, you will apply 49 para 1 letter A, which says that the buyer can declare the contract avoided, but that needs a fundamental breach of contract. And then Article 25 of the CISG explains what that means. It's something that you also have under English law when it comes to so-called innominate terms. So actually it needs a breach of contract that goes to the core of the contract, which is, as I have put it in bold, substantially depriving the other party of what it was entitled to expect under the contract. And then, and this is something which is coming from the common law countries that participated in the drafting of the CISG, this element of foreseeability. So it needs, a breach is fundamental when it substantially deprives the other party of what it was entitled to expect, and that consequence of the breach was foreseeable for the party in breach at the time of the conclusion of the contract. I'm coming back to that in a second. Next slide, please. Yes. So what does it take under Article 49(1)(a) in order for the buyer to be able to terminate the contract? These criteria have been developed in case law, so it needs a breach of contract that is objectively, so from a reasonable point of view, severe, which means that it must have some significance. It's not sufficient that there are just some scratches or that there are just some screws missing or so. I mean, it needs a breach which is rather heavy. And if there's such a breach, it also is necessary that this breach cannot be cured, at least not without unreasonable costs or without causing unreasonable inconvenience in another manner to the buyer. And third element, even if the breach is severe and even if it cannot be cured, there will be no fundamental breach and thus no right to avoid the contract if the fact that such a breach would be fundamental, so that it would really substantially deprive the buyer from what it was entitled to expect under the contract, was not foreseeable. So these are the three elements, and I'm going through those within the next slides. So please, next slide. Okay. As regards this first element, the defect must be objectively severe. Well, there must be a breach of contract, and that means, speaking about defective goods, we have to relate to Article 35 of the CISG, which tells us what conforming goods are. So goods are conforming if they correspond to what the parties have agreed, or if there is no specific agreement on the quality or quantity or other features of the goods, well, then the goods must be conforming to this. Well, they must be fit actually for the particular purpose which was made known to the seller. Or if there's no particular purpose that was made known to the seller, well, then the goods must be fit for the ordinary purpose. For example, I mean, if you buy a car you must be able to ride it, or if you buy tomatoes, they must be eatable, etc. What is made clear in case law is that there cannot be a fundamental breach allowing for a termination of the contract if you can resell the goods, or if you are producing something out of the goods that you bought, if you can use them for the production of the goods, even if this comes with certain restrictions. So there is a breach of contract, that's for sure. There are remedies for that, but there is not the possibility to avoid the contract, because there will not be a fundamental breach if you can make some use of the goods, even though with certain restrictions. So in case law, I mean, there are hundreds of cases actually by now. I'm also referring to this database CISG online that has been mentioned before. For example, if you buy a machine which has been described as being as good as new, and then what comes is a rusty, inoperative machine, then it's clear that it's not fit for the ordinary purpose. So not only is there a breach of contract, but if this machine is not operative at all, then there is a fundamental breach which will allow for a termination of the contract. The second example, similar to that, it's bioreactors that have been wrongly designed. I mean, if there is a defect in design, you cannot cure it. So it's clear that, I mean, first, it's objectively severe, the breach, and I mean, the defect. I mean, plus, and that will be the second criteria, but I mean, we can already tell it. I mean, if the design is defective, there's not much you can do about that. So that's definitely a fundamental breach, allowing for the avoidance of the contract. If you buy a horse, a sick horse, well, I mean, it's a breach of contract because a sick horse normally will not be usable for the ordinary purpose. But then is it a fundamental breach? Well, this will then depend on what the parties have agreed to. And here it was made clear to the seller that this horse was going to be used for jumping competitions. Well, then it's clear that it's a fundamental breach, because you cannot substantially make the use of the horse that you were hoping for. And then if you have a generator, I'm referring to the last example on that slide, that is producing an output of 250 kilo voltation, and then this is because you use it in Europe, where is a limit of voltage of 400 volt. Well, that's a fundamental breach, even though this same machine could be used at the advertised level in the US, because there's another voltage. So if you made clear to the seller that you will need this machine in Europe, well, then the fact that that the machine is functioning but not efficiently enough. So well, that will then again be a fundamental breach, which will allow for avoidance. Next slide, please. So if the breach is severe, well, then it could still be that you could cure it. There has been some controversy about the relationship of Article 49, which allows for avoidance of the contract, and 48, which says that the seller has the right to cure. By now, it has been made clear that there cannot be a fundamental breach as long as a breach, as severe it might be, can be cured. And for that, it is sufficient for the seller to notify the buyer of the fact that it's going to cure the defect. So obviously the seller can ask whether it's okay, but it can also just simply notify and say, I'm going to cure. Having said this, there will be no right to cure, which will be overriding the right to avoid the contract if the cure will cause unreasonable delay unreasonable costs or otherwise unreasonably burden the buyer, which is obviously a question of estimation and a certain risk that the seller has to assess before proceeding to the repair or replacement of the goods. Next slide, please. So if there is an objectively severe defect which cannot be cured, there still will be not a right to avoid the contract if it was not foreseeable at the time of the conclusion of the contract that that kind of defect will lead to a situation where the buyer cannot make any use of the goods, or where the contract doesn't make any sense for him anymore. So that's the element of foreseeability. Obviously, the buyer who wants to get out of that contract must prove all the elements that allow him to avoid the contract. So it must prove the fundamental breach. And under this third element, foreseeability, the buyer must show that it was foreseeable, objectively foreseeable for a person in the shoes of the seller at the time of the conclusion of the contract, that that kind of defect of the goods will lead to the fact that the buyer is seeing no use in this contract, which is extremely difficult to prove. That's maybe why I would say that as when it comes to avoidance of the contract, the CISG is rather seller friendly, unless obviously the parties have agreed otherwise. So yes, what I have cited here is a case of the Swiss Federal Tribunal saying that the buyer who wants to terminate the contract must show that the defect, the feature that now is defective was so significant to the buyer that the contract was standing or falling with this feature being correctly fulfilled. Okay, I'm handing over to Burkhard. Thank you.
Yeah, thank you. Thank you very much, Christiana. First of all, I would like to express my thanks to you, Fabio and Silvia, for inviting me to participate in this webinar. As you know, I'm working with the CISG for more than 30 years in practice with my clients, and I'm happy to any opportunity I've got to make to know to practitioners the existence and the advantages and certain disadvantages, of course, also, but in the end, practicability of applying the CISG in international sales. Well, I was asked to explain some further requirements of avoidance. Before I do so, please let me explain, ladies and gentlemen, you're listening, you're lawyers familiar with international relations, you may be surprised why we use this term avoidance. Avoidance in national legislation sometimes has a very specific meaning, whereas here in the CISG we use it instead of, well, other contexts we use the term termination, rescission, cancellation. These are terms which are not used under the CISG, and I think this is also quite one advantage of the CISG. We have got a common terminology, some terminology in common where no misunderstanding is possible if you use a correct term. Whereas termination, as far as I know, is not exactly the same for an American lawyer as for a British lawyer. There are some smaller differences. Well, we talk about avoidance, and Christiana pointed out very well the requirements that are to be met for the buyer to invoke avoidance of the contract, to resort to the remedy of avoidance. But after what we have heard from Christiana, these are not all the requirements. There are further requirements to be met. And please click on the slide, please. Yes, one more click. One more, please. And here you are. The buyer loses the right to avoid the contract if it is impossible for him to make restitution of the goods, substantial in the condition in which he received them. This is something I'm never seen a clause, a requirement I've not seen in other jurisdictions. There are sometimes, or there's of course always a consequence once the contract is avoided to give back what one has received. Each party has to hand back what it has received. But if one party is not in the situation to be not able to give back what she received, she may pay a certain price, an amount of money for it, instead of giving back. Under the CISG, and this is very special for the CISG, if the buyer is not in a position to give back the goods, to restitute the goods he has received in the condition in which he received them, there is no right of avoidance. He loses the right of avoidance. And there are only, well, there's three situations of a carve-out, which I will explain to you shortly. Next click, please. Click, click, click. Aware. The buyer does not lose the right to avoid the contract if the impossibility to give back, to hand over the goods as he received them, is not due to an act or omission of the buyer. Very few rulings, court rulings on this matter, but one ruling which I want to mention to you because it perhaps explains what the situation was about. There was a car sold, and the customs officers thought it was a stolen car, so they seized the car. And due to this fact, the buyer did not get hold of the car. It was seized, and due to the fact that the car was stolen, he avoided the contract. But on this condition, it was impossible for him to give back the car that was delivered to him, even though he had not received it. And under this situation, the courts thought, well, this impossibility to give it back is not due to an act or omission of the buyer. Second carve-out, perishment or deterioration of the goods as a result of the examination. Well, the steel wire was, the case of steel wire was delivered, and this steel wire had to be processed. It also had to be processed to examine whether it fulfilled the requirements, the quality, the goods that have been bought. Well, in that situation, the wire was changed a certain way by the examination. The courts decided the buyer didn't lose his right to avoid the contract. Even more, it's in this special case, due to the processing of the wire, it was of higher quality. It's worth more now than at the stage when the buyer received it. And finally, there's a carve-out when the goods have been sold, consumed, or transformed before the non-conformity was or ought to have been discovered by the buyer. The situation that has been discussed before the courts was that the buyer was not sure whether the non-conformity amounted to a fundamental breach. And meanwhile, the goods lost its properties. It remained the same, and the buyer used it. But once he was sure that the requirements for avoidance were fulfilled, the buyer stopped using the goods, and under this situation, the courts decided that the buyer could avoid the contract. Well, first, as I mentioned, these requirements, restitution of the goods, I don't know of any national legislation where this requirement is a requirement for avoiding the contract without any way to circumvent it. As I mentioned, according to German law, if I can't give back, if I can't restitute it, I pay a certain amount of money, and that's it. But we don't finish here. Further requirements for avoidance are required. There were, thank you very much. And yes, please click. Avoidance must be made by notice to the other party. Perhaps this is the requirement where most of the court rulings are dealing with. Avoidance made by notice to the other party. Of course, it's the written notice, no problem at all. If there's an oral notice, no problem either. There's no requirement in writing. But you should bear in mind that there are some countries which have adopted the reservation according to Article 96 of the Vienna CISG Convention, which says that written form requirements of the national statute law apply also under CISG contracts. And applying this, an Argentinian court decided that the avoidance must be noticed to the other party in writing. But this may be not very common situations. What is much more common, that in fact the party who's entitled to avoid the contract, the buyer, does not express its intent of avoidance, but it's implicitly expressed somehow. For example, the parties discuss that there is a fundamental breach because the non-conformity is of quite some importance. And thereafter, after the discussion where the parties do not agree, the seller asks the buyer to pay the purchase price. And the buyer says, no, I won't pay the purchase price. This is, of course, an implicit notice to the other party that wants to avoid the contract. The Austrian High Court has decided it's all right if the notice is made by bringing in a claim to the court, by claiming repayment of the purchase price already paid. This is equals a notice of avoidance, and under these situations, a formal avoidance is not necessary. According to Article 49, paragraph 2, there are certain further requirements to be met. In case the delivery was late and the late delivery amounted to a fundamental breach, then the buyer has only a reasonable time to use this remedy, to avoid the contract. And they have very few, I think altogether 4 or 5 court rulings which had to decide what was a reasonable time. Well, the cases they had to decide were that the buyer waited 3 months, 4 months, or 5 months, and in all these situations, the court decided it's too late. It's not a reasonable time period after the delivery was made. The delivery, as I repeat again, the delivery is late, but it's made. And once the delivery is made, this means that the time period, the reasonable time period, is triggered, and according to court rulings, 3, 4, 5 months are not reasonable anymore. In case of other breaches, particularly delivery of non-conforming goods, which amount in fundamental breach, also the buyer has to declare the avoidance of the contract within a reasonable time. Usually reasonable time after buyer knew or ought to have known the breach. Ladies and gentlemen, the CISG uses the term reasonable time, which we heard of before already. The buyer also is required to notify defect within a reasonable time. But using the same wording doesn't mean that the same period of time is addressed, because notifying defect and non-conformity of the goods, well, there's not very much the buyer has to think of. Whereas avoiding a contract, this means much more reflections to be done by the buyer to come to the conclusion that in this situation, avoiding the contract is the way how he should do it with the situation. In general, there are very few, quite a lot of court rulings. Some say for 4 weeks it's not reasonable anymore. Others say 1 week is okay. A Porsche vehicle was sold recently, that was decided 1 week is okay. Sometimes 2 months is not reasonable anymore. There are quite a lot of court rulings, and the vast majority saying not within a reasonable time. I think it's very hard, so I will desist from telling you examples from jurisprudence. it's very hard to come to a definite term that should apply. And this is due to the fact that I think it depends on the circumstances, whether the time is reasonable or not reasonable. Particularly with regard to seasonal products, ladies and gentlemen, there are shorter time periods considered to be reasonable than other products. There are two, we are in time before Christmas, almost time before Christmas, and obviously the Danish courts have to do a lot of cases where Christmas trees are sold. And so the Danish courts decided various instances that avoidance of the contract 8 days after the Christmas trees were delivered, too late. 11 days after delivery of the Christmas trees is too late. But I think this is due to the fact that, of course, the seller wants to know what he can, once they're given back to him, the Christmas tree, what to do with the Christmas trees. And this may have its impact on a reasonable time which this buyer has to obey. Ladies and gentlemen, you see on my slides there are two more examples after expiration of an additional period of time fixed by the buyer. And this continued industry question arises. Let's assume the time for declaring the avoidance of the contract has elapsed already. And let's assume that under this situation, the buyer sets another time to the seller and says, well, I was thinking it over, I give you another fortnight to deliver. And also this second fortnight elapses without any effect. Is the buyer then in a position to resort again to the avoidance of the contract or not? These things are discussed. There is no definite court ruling in this regard. I just mention it to you so that you may know that there are also possibilities you may use by drafting your contracts, by drafting your terms and conditions to better your situation. Finally, last click, please. Ladies and gentlemen, if the seller didn't deliver in time or delivered non-conforming goods due to an event that could be called force majeure, this doesn't mean that the buyer loses the right to avoid the contract. Force majeure, something like force majeure, is regulated in Article 79 of the CISG, and once these requirements are met, you can read in Article 79, paragraph 5, that the buyer loses the right to claim damages. But all the other remedies that, according to the CISG, exist are handed over. Well, I'm sorry for exceeding the time. I thought it was just a few slides, and what less time perhaps could be interesting. If I may ask Sylvia, ask lawyers from different countries to tell us what the situation in their country, according to their national statute laws, if you want to terminate a contract due to deliver non-conforming goods. Thank you.
Okay, thank you, Burkhard. I don't know if it is possible for the people to answer because they cannot really open the microphone,
yes.
The participants.
Yes.
Oh.
Yeah, but they can use the chat and answer a question. I'm sorry because I said before that people could use the chat, but actually it is the answer Q&A section for the. So if someone would like to say something, could use that. Yeah. In any case, yes, I would like to thank you, Burkhard and Christiana, for your presentation. And yes, so, and all the speakers for that. So now, yes, as I said, if somebody wants to put some questions, so far I've seen that there are 2 questions for our first panel. So the first question is, do you think that a judgment issued by the Italian court would be recognized and enforced in the US? I'm not 100% sure that in that case it would be recognized and enforced. We should ask a US lawyer and check about possible bilateral agreements between Italy and US, referring to the case, of course, we made. But it's a question of strategy in any case, because, I mean, first of all, it depends. We have made an example, but for example, in a case I had, a similar case I had, the other party was Japanese and was threatening a huge proceeding there. And we use this strategy to anticipate with the proceeding, starting a proceeding in Italy, and that company came to Italy when there was the terms for him to appear in court, and we settled. So it depends, of course, how in our example, how what were the priorities, how much was the price still due, and if it was more important for the Italian brand to avoid a court case in the US, where probably there would have been you know, maybe an expertise for the damages, so a big case, maybe that could be a strategy to anticipate in Italy. But of course, there is not a right or wrong answer, and the strategy shall be made on a case-by-case basis. And then the second, another question also to our panel. Can you please mention some Italian case law stating that Article 1341(2) does not apply to jurisdiction clauses? There are many cases, many decisions on that, because we must pay attention on the fact that the derogation of the forum clause regarding the internal forum clause of territory within Italy, this is subject to this rule provision, Article 1341, but the jurisdiction clause not. So actually I have checked this just to look for recent decisions on this point just when I was preparing, and I can mention a decision of the Supreme Court, Italian Supreme Court. It's number 361 of January 10, 2023. But anyway, you all can 2023. So, but there are many others in any case, and you can, if anybody wants to know something more, can just call me, and I can provide with more information. So I don't know if there are other questions in the meantime. Burgard, you have the... Okay, go ahead.
I consider myself not only a CISG lawyer. First of all, I'm a German lawyer, and I would like to take this opportunity to highlight a very important difference between German sales law and CISG. Under German sales law, if goods are delivered that are not conforming, the seller may require one or two try to repair the goods. If it doesn't achieve a positive result, then the buyer may terminate the contract, and this right can't be excluded. If it's a complete minor non-conformity, that's no difference, but it does not have to be fundamental breach like under the CISG. The German High Court has decided in various instances that if German law applies, not the CISG, and the goods do not conform, the seller may one or two tries to repair the goods, but if these fails, the buyer may terminate the contract, which cannot be excluded, at least not by general terms and conditions. And the buyer has got this opportunity up to the time limit that's according to for statute law, time bars for claims. That's normally 2 years. So I think if you want, as a seller, want to make it more difficult for the buyer to avoid the contract with an international matter is serious complication, then you shouldn't exclude the CISG and at least not agree on the German law. Better stay with the CISG.
Okay, Burkhard, I take the opportunity because there is a question saying CISG law seems rather seller-friendly. An area where it is not, it is seller-friendly, you say. But there are also...
In this aspect, there are other aspects where it's more buyer-friendly.
Yeah, this question, I think, was an open question referred to in general to the CISG. So you don't agree that there is only seller-friendly, or can you mention some cases in which it is also on the side of the buyer, or
maybe I
For
can
example,
yeah.
Sorry.
yes,
Article 79 would be an example also to see at least the difference. I don't know if the question now comes from a civil law jurisdiction. I presume so. Article 79 is different than many of our legal systems, which says damages you can only ask for if there is really also fault on the side of the parties. So mostly, I presume it's going to be also the seller who is going to pay damages. That means even if the seller is not at fault, under Article 79, you have to pay damages. So that means it is only these very high threshold of force majeure cases where you can have an exemption under the CISG. So that means it is a bit closer to a strict liability system, which is more influenced also by the common law systems where we have in contract law strict liability also. That means there you could say, yes, maybe it's going to be harder for the seller, but 79 applies again for the buyer as well as for the seller. So if the buyer is asking for damages, the seller is going to be liable without fault, vice versa, if the seller is asking for damages, the buyer. But it is, I would say, really a convention where you have a balance, striking a balance. It's not all the time protection of the seller or the buyer.
Okay, good, thank you. There are other questions. We cannot take all of them because we are a bit late, but we can take another one. Says, how often is CISG really used in international sales? Is there any statistics indicating its relevance? For example, what would an Italian or German or French manufacturer most often require in terms of applicable law? I could say that almost all our clients apply the CISG, but as a matter of fact, many companies are excluding it, as a matter of fact. That's why also we are trying to explain that there are also good and positive outcomes in choosing it.
I think that our strategy as IDI is not necessarily to say that you must use the CISG, but at least to show the advantages and to give our associates the possibility of making a true and giving a true understanding about the pros and cons of the CISG. Because in most cases, they decide without knowing why they are doing it. They do it because they have been told to do so, and that is wrong. Then, of course, you may decide that your national law is better, you may do very things, but you must know what it means to use the CISG. And I think that all these exercises we are doing here have that purpose, to make it known to our members.
Good.
You agree?
Absolutely. And as I said also during my speech, you don't think always to exclude the CISG in total. You could also revise it, change some of its provisions, which you do not think they are suiting your needs. But otherwise, it is much easier to negotiate because we have now almost 100 countries which are participating to the CISG. Why should you try to choose one or the other law? CISG is really making things much easier. Maybe to one remark, the limitation period of 4 years, that convention is, I've just looked at, maybe it has more parties, but still with 30 parties, it's not widely applicable. So that means it is not a convention like the CISG, which is applicable. That means here we have a problem, really.
Yeah. And the last issue on jurisdiction clauses in relation with Italian law, the reference to the Brussels Convention actually is that reference is only to alternative jurisdiction criteria, but does not include reference to the provision on the choice of forum clause. So it is a specific issue, but this is really Italian. So I think we have answered to all the questions. And yes, we would like just to keep a moment to mention, to speak about our new conference. So first of all, on this topic, I mean, we have discussed this topic during our past conference, and it was very lively and interesting discussion. We have repeated here with other issues, and I think it has been very interesting, and I would like to thank all the speakers to be with us and active again in this new session. And yes, I hope that also this was a good opportunity for all of you participants who are not already member of IDI to decide maybe to join us and to be part of our group of people. And yes, just mentioning the next annual conference. Next annual conference will be in Torino, our hometown, on 6th and 7th of June, of course, 2025. And the main topic of the Friday session, the plenary session, will be on use and restriction to the use of trademarks and other IP rights, and also protection. So expanding in countries where you do not have or you cannot have a protection of your trademarks. What can you do? Or also using the protection of trademark as a means for against online resellers which are selling your products, so free sellers in this case. So the main topic of the Friday will deal with protection and use of the trademarks in distribution and franchise network. This is and then we have already started preparing the program, and we are involving very important and relevant speakers from all different countries. So with a lot of discussion panels. And then the workshops will be, the first workshop will be on artificial intelligence in distribution and franchise agreements. And we will try to focus on the contents, because of course now it is, even if it is not so easy, but we will try to involve companies who are already using artificial intelligence in order to have an in-depth evaluation, and also of course starting considering the new rules we have, at least in Europe and in other continents. So we will try as much as possible to have a concrete, an in-depth approach of this topic, not just general as it is sometimes happening. So the second workshop will deal with new players in online distribution. So that we had a decision in Italy which regarded the influencer in certain circumstances as a commercial agent, so granting the protection of the agents. And there is, I think, also a decision in Germany in this sense. But we will deal also with other players, I would say, in the online distribution, such as personal shoppers, maybe, or also online, maybe agents working only online platforms and aggregators. So this type of players, new players, we would say. And the third workshop, we deal with product recalls, but not focusing, of course, in the specificity of defects or problems of not on the sales aspects, but more on the impact on the distribution network. So the necessary collaboration with the members of the network and the aspects of managing a possible recall or threat of recall of products in distribution networks. So these will be the topics. We hope that we expect the same number as we have participants as we had today, more or less. This is the numbers we normally have, like 170, 180 people coming to our annual conferences. And so particularly for those of you who are not regularly coming, that could be, we hope, an opportunity to join us. And that's it for me. If you want to say.
Yes, I wanted simply to say mainly to those who are participating to this seminar, not to this conference online, those who are not yet members of IDI, that IDI is a nice family of people who like each other, who meet each other every year. And I think it's really something not only useful, but also nice to live in. And so I would welcome everyone who wants to join us if he understands the advantages of IDI, where we are always trying to focus on issues that are not theoretical, purely theoretical, but that are real. And we try always to understand what people dealing with distribution need really, and not only theoretically. Silvia is not completely in agreement, but I think I would like to do something more on this matter of CISG, and to write something, if we write it, particularly make a list of cases and give our members the possibility of looking at all the cases dealing with these matters which we dealt with today.
Okay. Yeah, actually, you raised an issue that is very important that I take the opportunity to mention, that we have decided as IDI to expand also into international sales. So as for those who knows, we have already a section on commercial agency, distribution and franchising, and we will introduce a new section on international sales, because we have seen that it is of interest of many people dealing with distribution, and because it's so related and important for all the companies and the members of IDI. So we are creating now a working group which will work on country reports, but also a general report dealing with the CISG, so that people can refer to that general report on the CISG, and then country reports. We will also make probably, yes, we will also have general conditions of sale on the side of the seller and on the side of the buyer, because as we also have for the other contracts, we have the principal friendly, agent friendly, and balanced. So we will do the same for sales. And yes, of course it's a long process. It's not immediate, but we will start very soon working on this new project. And so, yes, we will work in that direction.
Yes.
Maybe it will not possible immediately to make a collection of all the cases, but yeah.
Silvia, maybe we can make also a questionnaire, because the question was how much is the CISG excluded, and ask also all our members if they are excluding the CISG or if they think of not excluding the next time. So we would have more statistical information also.
Yeah, that could be a good question.
I want to convince them that if they want to exclude the CISG, they must really know why they are doing it. Because that's, I think, a problem of ignorance, and we must fight against ignorance.
Yeah.
Another thing, if you have good reasons to do it, you can do it, of course. And this is, yeah, you agree, no, Burkhard?
Absolutely.
I have seen Burkhard who agrees, I think. So, thank you all. I think it was very nice. Really, this possibility given by internet yes, the only disadvantage, you cannot share a meal. That's the only problem, because actually the best discussions are made at table. But anyhow,
That will be done in
it's
our next
already very
conference.
much.
Yeah, okay.
Okay.
Very good.
Thank you very much, Silvia and Fabio.
Yeah, thank you. Thank you all
very
the
much.
speakers, all the participants, and thank you very much. It was really,
Thank you so much. Bye.
thank you. Bye. Bye to everybody. Bye bye.
Bye-bye.
Bye. Bye.
Bye.